Good morning to everyone present here and welcome to day 2 of the Bangalore ADR week. Our first session of the day is being chaired by Justice S.R. Krishna Kumar, and the panelists include an eminent senior advocate and partners from some of the leading firms in the country, all of whom have dealt extensively with arbitrations, including complex commercial arbitrations and the challenges they bring. Over the last 2 days, a common theme which ran through starting from the inauguration ceremony through various panels is how arbitration and other ADR mechanisms, although welcome in terms of their ability to solve complex disputes, have not really been able to achieve the goals through which they were initially set out. The current panel will delve deep into how and in what manner these challenges arise, how best they can be met, and also best practices to make sure that the objectives of the various alternate dispute resolution mechanisms are not lost. I would now request Mr. Sarfaraz Hussain, Deputy Director of the Karnataka Judicial Academy, to introduce Justice S.R. Krishna Kumar.
Dignitaries, distinguished guests, invitees, participants, ladies and gentlemen, good morning to all of you. It is my honor and privilege to introduce Honorable Mr. Justice S.R. Krishna Kumar, a distinguished and accomplished jurist. His Lordship embarked on his legal journey at the University College of Law, Bengaluru, where he graduated with a degree in law. His Lordship was enrolled as an advocate in 1992 and since then has practiced law for 3 decades before various courts of law and tribunals. His Lordship's expertise spans over a wide range of areas, state a few. His Lordship's extensive experience and exceptional legal acumen led to his elevation as the additional judge in 2019 and permanent judge of the Honorable High Court of Karnataka in 2021. Throughout his journey, his Lordship has commitment to justice and rule of law. Please join me in extending a warm welcome to His Lordship Honorable Mr. Justice S.R. Krishna Kumar, Judge High Court of Karnataka and Governor, Karnataka Judicial Academy, with a big round of applause. Thank you so much.
Thank you all. I now have the privilege of introducing the panelists that will be participating in today's discussion, starting with Dr. Aditya Sondhi. Dr. Aditya Sondhi is a senior advocate practicing before the Supreme Court of India, and he appears extensively in arbitration matters, both domestic and international, and acts as an arbitrator as well. Dr. Sondhi has taught a course on arbitration in NLSIU Bengaluru and acts as an advisor to the newly founded Arbitration Bar of India. Please join me in welcoming Dr. Sondhi. Up next, we have Mr. Rajendra Barot. Mr. Rajendra Barot is a senior partner at AZB Partners and heads the firm's dispute resolution practice. Mr. Barot has over 27 years of experience and is highly regarded in India's dispute resolution market for his expertise in high-profile domestic and international arbitrations and litigation. He has been consistently ranked by Chambers and Partners for over 15 years as a leading lawyer in arbitration and dispute resolution. Mr. Barot regularly advises and represents clients in institutional and ad hoc arbitrations seated in and outside India. Mr. Barot also advises leading global PE funds, MNCs, insurance companies, and global leaders of the telecom and mining sectors. Please welcome Mr. Rajendra Barot. Next, we have Mr. Manu Kulkarni. Mr. Manu Kulkarni graduated with a gold medal from Nalsar, Hyderabad, and was called to the bar in the year 2008. Mr. Manu heads the dispute resolution practice at Puvaya & Co. and is consistently engaged in several high-profile litigations and domestic and international arbitrations. Mr. Manu is a visiting faculty at NLSIU and also teaches at Nalsar, Hyderabad. Mr. Manu has been ranked by Chambers and Partners as a leading lawyer, as a litigation star and one of Asia's top 40 under 40 by Benchmark Litigation APAC, and ranked by Asia Law as a notable practitioner in dispute resolution. Mr. Manu has consistently acted for pro bono causes regarding environmental protection, protection of rights of the differently abled, planned urban development, and unauthorized constructions. Mr. Manu has also been one of my first mentors in this profession, and it is my honor and privilege to welcome you to this panel. So, last, we have Mr. Karan Joseph. Mr. Karan is a partner with Shardul, Amarchand, Mangaldas with the firm's dispute resolution practice and specializes in litigation, arbitration, and strategy. A graduate of Christ College of Law and a recipient of an LLM from Columbia Law School, Mr. Karan has over 10 years of enriching experience in commercial, civil, employment and constitutional law and appears regularly before the high courts and tribunals and trial courts across Karnataka and across the country. He is also frequently appointed by the National Company Law Tribunal, Bengaluru, to preside over shareholder meetings as an independent chairperson. Mr. Karan also acts as the managing trustee of the General K.S. Thimmaiah Memorial Trust. Please welcome Mr. Karan Joseph. And with that, I hand it over to the chair.
I would request Justice Krishna Kumar to start the session.
Good morning. I think all of you had a nice breakfast and bright, and all the panelists also. Today's panel seeks to delve deeply into the effectiveness of India's strategic initiatives aimed at strengthening the legal and institutional framework for dispute resolution, with a specific focus on alternative dispute resolution. Our goal is to critically assess whether these efforts have indeed positioned India as a global leader in dispute resolution, or if substantial gaps persist that must be addressed. India's embrace of ADR, particularly through arbitration, has been a cornerstone of its strategy to enhance business environment and reduce the judiciary's backlog. Notable progress has been made as demonstrated by the establishment of specialized institutions like the Arbitration and Conciliation Center at Bangalore, and the increasing reliance on international arbitration and the international arbitration hubs such as the Singapore International Arbitration Center, SIAC. These developments underscore India's commitment to fostering an arbitration-friendly environment, crucial for attracting international business and investment. However, India's journey towards becoming a global arbitration hub remains fraught with challenges, including excessive judicial intervention, inconsistent enforcement of arbitral awards, and the prevalence of ad hoc rather than institutional arbitration, all of which undermine the predictability and effectiveness of the ADR processes. The inefficiencies inherent in traditional litigation, such as delays, high costs, and systemic backlogs, have driven businesses and other stakeholders towards ADR as a faster and more cost-effective alternative. Arbitration and mediation in particular offer promising solutions for resolving disputes in a budget-friendly, business-friendly manner. The advantages of ADR, such as confidentiality, the ability to select specialized arbitrators, and the focus of preserving business relationships have made it an attractive option for commercial disputes. However, the ADR system in India is not without its own challenges. The inconsistent quality and training of ADR professionals and the lack of uniform standardized procedures continue to raise concerns. These issues threaten to undermine the integrity and credibility of the ADR mechanisms, leading to hesitancy among parties to fully commit to these alternative methods of dispute resolution. Recent legislative developments such as the Mediation Act 2023 represent a significant milestone in India's ADR landscape. The Act seeks to formalize and regulate mediation, ensuring confidentiality, voluntary participation, and the enforceability of mediated settlements. It introduces a comprehensive framework for mediation, including provisions for institutional mediation, international mediation, and the integration of mediation into the court system. The Mediation Act aims to address some of the long-standing legislative hurdles in India's ADR ecosystem, such as the lack of institutional support and the need for standardized practices. As we look closer at the evolution of ADR in India, it becomes evident that the system's success depends not only on legislative reforms and the institutional support, but also on the broader acceptance of ADR mechanisms across various segments of society. The government has made significant strides in promoting ADR, particularly through initiatives like the 2019 and the 2021 amendments to the Arbitration and Conciliation Act 1996. These amendments aimed to streamline arbitration processes, reduce court interference, and make India a more attractive destination for international arbitration. However, these legislative efforts are not enough on their own. They must be accompanied by a cultural shift that embraces ADR as a primary means of resolving disputes. Another key development reshaping the ADR landscape in India is the rise of online dispute resolution, ODR. Leveraging technology, ODR offers a platform for resolving disputes efficiently, particularly for parties in remote locations or those dealing with cross-border disputes. The potential of ODR to democratize access to justice is immense, especially given India's vast geography and the disparities in access to legal resources across different regions. ODR can bridge these gaps by offering faster, more cost-effective resolutions that are not bound by the physical limitations of traditional courtroom settings. However, the widespread adoption of ODR faces significant hurdles, such as concerns over the enforceability of online mediated awards, data security issues, and the limited awareness of ODR mechanisms. Additionally, the legal infrastructure needs to adapt to accommodate the unique challenges posed by digital dispute resolution, ensuring that the rights of all parties are protected throughout the process. As we proceed with our discussion, we must consider critical questions. Has India's arbitration system truly met its objectives of cost effectiveness and efficient justice delivery? Number two, are our ADR mechanisms sufficiently equipped to address the needs of both domestic and international stakeholders? Number three, can the recent legislative efforts, such as the Mediation Act and the ongoing developments in ODR, overcome the systemic challenges that have historically plagued India's ADR framework? Addressing these questions is essential to sustaining public trust in ADR and ensuring its viability as an alternative to litigation. Without sounding preachy, if I can recall Mahatma Gandhi quote, and I quote, "The best way to find yourself is to lose yourself in the service of others," unquote, resonate profoundly with the mission of ADR. This principle calls upon all stakeholders to commit to addressing the present challenges within the ADR ecosystem, such as inconsistent enforcement, delays, and accessibility issues. By doing so, we can ensure that the ADR systems deliver not just swift resolutions, but also equitable justice. Restoring and maintaining public trust in ADR is about more than preserving its integrity. It's about fulfilling a collective responsibility to build a more just and harmonious society. This discussion happening today is not merely an exercise in identifying challenges. It's an opportunity to explore actionable solutions that can strengthen India's ADR framework. The future of ADR in India hinges on our ability to confront these challenges and ensure that our dispute resolution systems are efficient, fair, and accessible. By addressing these issues collaboratively, we can work towards establishing India as a reliable and attractive destination for arbitration, thereby enhancing the efficiency and fairness of our dispute resolution systems for all stakeholders. Without continuing any further, I now pass it on to my fellow panelists who can take over. Thank you.
I invite Dr. Sondhi to share his thoughts on the subject.
Thank you, Justice Krishna Kumar, for setting the tone for this morning's discussion. Honorable Judges, Justice Uma, Justice Nawaz, respected judges from the District Judiciary, my fellow colleagues from the bar, Mr. Barot, Manu, Karan, ladies and gentlemen. My compliments to Harish and his colleagues for putting together this long overdue Bangalore ADR week, though it's only over the weekend, but I'm sure it'll, like arbitration, it will stretch in the days to come. I will be speaking to you about the obvious and excessive interface between arbitration and courts. It's a theme that has been long talked about, but I think we need to continue to focus on it because that's really the reason that the trust deficit exists. The topic for today is trust, distrust, etc. for India Inc., in other words, corporate litigants. And this trust deficit, I think, in my limited experience with arbitration, comes from the constant interaction that arbitral disputes have with the courts. And we have to now try and see how to strike that fine balance where arbitral awards are not some kind of carte blanche for the arbitrators to get away with anything, but at the same time, the judicial review over such awards is limited and refined. I recognize Justice Punacha in our midst. Now, Section 5 of the Act, interestingly and very relevantly says there shall be no interference by courts except as provided, and it's a non-obstante clause. But that's really the trailer. Picture abhi baki hai. And from the top of my head, just yesterday, I was trying to list out the various stages and various issues that crop up in arbitration disputes vis-a-vis the courts. And starting from Section 11, and this is all well known to you, I won't dwell too much on it, but from Section 11 onwards, which is the appointment of an arbitrator, all the way to the Section 34, 36 enforcement, there are many, many nuanced issues which detain the courts in matters of arbitration. I think it's not only a question of how many stages you go through. We know that 9, 11, 34, 37, then 36. But the question is the wide scope within each of those stages for the courts to interfere. Now, in 8, 9, and 11 itself, courts have had to consider as to which court must either appoint or exercise jurisdiction under 9 or 8 as the case may be. Then comes the vexed question of non-parties to agreements and composite agreements. In 11, we have seen years and years of decision-making, matters being referred to larger benches, all the way from good old Konkan to where we are now post-amendment, as to whether that power is administrative or judicial or a hybrid. I remember when Justice Ravindran used to sit as the Section 11 court, I'm sure Justice Krishna Kumar remembers this, he used to say, take off your band and argue because you're not appearing before a judge. It used to be a Friday afternoon. It was a relaxed process. So it was really not adversarial. You had to simply show the existence of an arbitration clause and that, of course, you were in the right court and get an arbitrator appointed and leave everything to the arbitrator under Section 16. But we have come full circle. We have gone to an extent where the courts have said that the power is actually judicial, that live claims, in other words, whether limitation is a bar or not, must be gone into, and then post the amendment, return to a scenario where the existence of the agreement is sufficient. But the existence of the agreement, I think, is also a simplistic thing. There may be an agreement before you, but I do think then when the matter is before the High Court, the court is still required to consider whether the right parties are before it and whether, broadly speaking, the dispute is arbitrable. And this is where the plot thickens, because that entails interpretation and discretion. Of course, in all gray areas, the matter should go to arbitrators. But what if somebody comes to the court in a section 11, in a, let us say, a shareholder dispute, and in its notice, the petitioner or the claimant has said that I want to seek liquidation of the respondent. And that is the prayer leading to the section 11. Surely a section 11 court will not say, yes, there is an arbitration clause, go to the arbitrator, because it's an accepted matter. Arbitrators cannot decide a matter of liquidation. It's a statutory public law remedy. And I do think that in our temptation of saying, let everything go to the arbitrator, in some ways we have created this mistrust. And I say that because then that opens up the gates for all sorts of matters to be referred to arbitration. And that does not earn arbitration a good name. A party who knows that an arbitration ex facie is not maintainable still has to go through that process. Of course, you will say file a section 16, but if the 16 is rejected, we know the law, that you have to go through the entire arbitration and then come back to the court under section 34. And that means time and money, and I think more than that, it means a loss of credibility to the system. The other aspects of even stamping of an agreement, the section 34 patent illegality principle, which we are constantly grappling with. If you ask me quite honestly, what are the contours of section 34, I will struggle to tell you. Because we have now seen the recent Delhi Metro judgment, and I believe Karan is going to speak about it. So maybe till one station I will take the Delhi Metro, then you can take over from there. But the Metro judgment, as you know, is an extraordinary case wherein a curative petition, an award, has been set aside. And this is after 5 rounds of litigation, where an award was upheld by the section 34 single judge in the the High Court, reversed by the division bench of the Delhi High Court. The SLP and review were both rejected, but in a curative, the court thought it fit that the award needs to be set aside. And in Delhi Metro, the earlier judgments in Sanyong, Associated Builders, etc. are cited, which speak of principles such as, of course, egregiously or patently wrong orders and ignorance of substantive law, but they also speak of slightly more amorphous concepts such as considering irrelevant material, discarding relevant evidence, and wandering outside the contract. Now, each of these phrases, as we know, is a matter of interpretation and discretion in any circumstances. So whether an award is patently illegal is not so patent, in my opinion. Not to mention there that the question of remand and whether a court under section 34 can remand a matter to the tribunal or modify the award itself is up for grabs. The law is fast changing. There was the view in McDermott that you can only set aside and leave parties to begin arbitration again. But as we know, in certain circumstances where an award is severable, the courts have said that it can be partially set aside. When it reaches the Supreme Court in exercise of Article 136 and 142, there is then scope for modification, at least on slightly less substantive matters such as interest, etc. So really what we thought of as a pyramid, starting with a base of the arbitral tribunal and a narrowing sort of incremental but narrowing scope for judicial review, we have now come to realize that at the top of the pyramid is actually a plateau and anything can really happen. And that, with my respectful submission, does not sit well with the idea of arbitration. Even in section 37, or for that matter under section 29A when it comes to extension, or section 42 as to which court you must approach, there has been great deal of litigation as to which is the court, who has jurisdiction, etc. And the fact is that if we look at the larger picture, at every stage of arbitration, pre-commencement all the way to enforcement, the courts are central to the outcome of an arbitration. Now look at what suggestions or solutions we can find to find that balance that I mentioned earlier. Now, I have been thinking about this. Article 224A, sir, provides for ad hoc judges, which is loosely, the Constitution doesn't use that phrase, but for retired judges to be brought back to the bench to decide cases. Now, we've not really used this option, but it's there in the Constitution. And it provides, therefore, not just in arbitration, but in any sphere, to have retired judges who are familiar with a certain substantive subject of law to return to the bench and aid in disposal of matters. This is certainly an option, I think, in the context of arbitration, because retired judges with rich experience in commercial law can most certainly, I think, fill that void. I'm aware that we have the Commercial Courts Act and commercial divisions in the High Court, but the fact is that commercial divisions are often also burdened with other rosters. So therefore, it's not necessary then that the commercial divisions in every High Court are hearing only commercial matters. And commercial matters go beyond arbitration in any case. The related suggestion that I would like to make, and I thought it was an original thought till Manu told me Justice Anu Shivaraman has already flagged it yesterday, but I would still like to develop it, is the scope for us to create an arbitration tribunal. Now, I welcome Justice Anand Bhai Reddy. The scope to create an arbitration tribunal. And this, of course, requires if not a sea change, certainly a wide change in the Arbitration Act. But let us, I think, test it and see if it's going to lead us towards that happy middle path of some judicial review, but not too much. Now, if we've been able to create tribunals for everything from debt recovery to green tribunals, etc., then why not an arbitration appellate tribunal? The arbitral tribunal in itself is a tribunal, as an original tribunal. There is no difficulty in that tribunal having non-judges. You have engineers, or in many cases you have laypersons, even elders in families, acting as arbitrators and writing awards that have a binding force of law. But the moment we go beyond the award, we bring in this extreme interface with the court and judicial review. But on a tribunal, and this would of course be an appellate tribunal, which substitutes section 34. I know the word appeal doesn't sit well with 34. We can call it the arbitration tribunal or the arbitration adjudicatory tribunal, call it what you will. But it will essentially exercise the powers of section 34. And on that tribunal, then you have scope to bring in the very same retired judges that I spoke about, who have rich experience in commercial matters. Added to that, and I think this is important, have scope to have counsels who have a rich practice in arbitration. I'm not making a pitch for myself, but I'm just saying this. Have counsels who have some rich experience in arbitration to be the additional members of that bench. What that then does is, it focuses the scope for judicial review upon arbitration matters and the contours of arbitration. Of course, that would mean taking the jurisdiction away from the civil court. We have seen with the experience of NCLT, sir, that some of our best experiences, our best judges on the company side, for example, were in the High Court. And I personally felt personally aggrieved when that jurisdiction was moved to the NCLT. But at the same time, we have to look at the realities of the matter. And if you're able to then create this tribunal, which exercises section 34 jurisdiction, and provide, I want to also suggest this, provide therefrom one last statutory appeal to the Supreme Court, you're doing a couple of things. One is you're taking away one stage of judicial intervention. The second thing is you're creating a specialized body which can go into the arbitral awards. I'm aware that appointments to these bodies will be a different ball game, but at least in concept we should try and think about this. And providing a statutory appeal to the Supreme Court against this tribunal, of course, will never take away the power of the court under Article 136. But whatever my limited experience tells me is that when a statutory appeal comes before the Supreme Court, somehow the court looks at it very differently from an SLP. And the scope for discretion in an appeal is even more limited. And the statute can say that the appeal will lie only on a substantial question of law, coupled with some grave miscarriage of justice, so that every appeal is not entertained. I do think that this could be food for thought for us to take matters forward. Otherwise, we have this strange hybrid where in an arbitration you can be before non-legal persons, but thereafter the real legal arm wrestle begins. And as is done in other jurisdictions, I think the concept of indemnity costs, imposition of heavy costs on unsuccessful appellants must be introduced. I'm aware that I'm running out of time. I want to just make two other short points before I hand over. I do also think that this trust deficit in arbitration has arisen because somehow arbitration has become a high-stake alternative. ADR actually in India was never supposed to be an alternative only for high-stakes litigation for persons who could afford it. Arbitration was meant for all and sundry. And I wonder why we are not moving now towards an opt-in scenario. We typically like to opt out of arbitration. Even if there is a clause, the respondent in almost every case would like to raise a defense to arbitration on the lines of the various aspects that I had mentioned earlier, from arbitrability to a live claim to non-parties, etc. But why is it, let us say, in a partnership dispute, where say the partnership deed does not contain an arbitration clause, why is it that partners would not be tempted to say, let us go for arbitration? Or for that matter, in a partition matter. I'm not speaking about accepted categories. You cannot take matrimonial disputes or criminal disputes to arbitration. But civil disputes, which are arbitrable, I think we need to move towards that paradigm where they become more attractive options for persons to say, let us actually opt for arbitration than opt out. Sir, you spoke about equitable justice. I think that would be a step forward and really make us a robust arbitration destination. I don't think we should be carried away only with big ticket arbitrations and litigations because they run on a sort of budget and on different wheels from everyday litigation. Lastly, I would say, and I know Ritika had said that we must have something positive to say. So I do want to say this in all seriousness, that I think the arbitration bar of India, to which I've been fortunate to have been appointed an advisor, I think is a step forward. We have long argued that there is a need for a special arbitration bar in India. These policy changes, legislative changes, interpretation, etc., as council, we cannot control. But certainly as the bar, we can do two things. One is we can bring in the best practices and bring in practices that actually nurture arbitration, right? To do away with adjournment culture, to do away with the necessity to drag out cases. And those of us who have done arbitrations, we know that good arbitrators will give you no leeway. You will have dates fixed in advance and you have to go on with your matter and complete your arguments in a time frame. And I think the arbitration bar can reach out further to the younger bar and try and develop that. The other thing would be it gives you some scope to negotiate, to bring policy matters to the forefront so that, you know, decision makers can take some stock of this. I think all of that, friends, would bring us to a greater degree of trust in matters of arbitration. I thank Justice Mudgal for also heading this ADR week, and thank you very much for having me.
Thank you very much, Aditya, for the insightful, starting off with the trailer and then the plot thickened and then the climax was excellent. Solutions are, solutions I won't say are given today, but proposed by Aditya, and very interesting, especially the establishment of a arbitration appellate tribunal is an extremely thoughtful and interesting step because it will have a great impact on the entire arbitration process. As far as I can see it, there are dual problems. One is the enactment itself. Now that, as Aditya suggested, needs amendments, and that is left obviously to the to all the concerned persons. I won't say particular, all stakeholders involved. The second thing, with due respect, is the quality of arbitrators also, if I may say so at this, on this occasion. So we need, I don't need to say much, we need experienced people who are appointed as arbitrators should necessarily be, should have dealt with commercial matters, arbitration matters, so that they can be effective arbitrators. Otherwise, the same scenario would continue and nothing would really change. And insofar as Article 224 capital A is concerned, ad hoc judges being appointed, again we need to choose from experienced judges who have dealt with arbitration matters. Insofar as the other issue flagged by Aditya, that every respondent in a Section 11 petition, invariably, the first date of hearing matter comes up with experience, I'm saying this, says 2 weeks' time. Then after that, 2 more weeks' time. Then after that, objections, preliminary objections, then final objections, then senior will come and argue, and then end of it, nothing remains but one simple arbitration clause or an arbitration agreement, which we will refer to arbitration after 3 months. And that with a lot of persuasion. And by chance, there is some kind of a vague, evasive denial either in the reply notice or in a statement of objections, then a SLP is filed. The entire arbitration process gets derailed. Now, this with the experience I'm saying this, I understand all the juniors, the junior counsel are senior driven, seniors are firm driven, firms are litigation, the parties driven. I understand 10 pages of statement of objections will lead to what? But at the end of the day, I mean, if we are talking about something positive, then I think it's high time we strike a balance and at least appear to be reasonable before the court, before we unnecessarily drag on arbitration matters. Yes. Now, in fact, the recent judgment in SBI life insurance, I think, the eye of the needle, stale claims, all that I think the 3-judge bench has done away with and said, because of the 2015 amendment, it's only about existence of arbitration agreement. Correct me if I'm wrong, that eye of the needle, all that Justice Pardiwala says, no longer available to any respondent. So we're talking essentially about good arbitrators who have domain expertise. We're talking about lawyers who cooperate with the arbitration process. And we also talk about changes in the law. I think these 3 things, a coordinated effort on all these 3 fronts will definitely help us, coupled with, of course, an excellent idea with regard to, as regards arbitration, appellate tribunals. So now let's move on to the next speaker, Mr. Rajendra Barot, for his thoughts.
Hello. Yeah, hi, good morning, everyone. I think thanks for the organizers to provide an excellent platform, which really, in a sense, enables all of us to throw our ideas. And then, obviously, as they say, the first step towards a solution is identifying the problem. So where I'm going to go is I'm going to try and give a perspective of a practitioner who, through my career, I've seen a lot of foreigners ask us questions in terms of what happens in India if there is a dispute. So a little bit of background. I come from that part of Mumbai, which is where the thriving middle class stayed. And I remember when I was a teenager, if you had a telephone connection in your house, that was an added reason for which somebody will be absolutely keen to buy your house. Coming from there, you are talking about a country which today has the 2nd highest number of mobile connections. Coming from a time when you used to show off your mobile, that I have a mobile phone. I think life today is where if you say I don't use a mobile phone, people will envy you. So, to kind of continue what technology, what foreign direct investment has done to us, I remember there were trunk calls, where you had to book a trunk call. There was a simple, urgent and a lightning trunk call. All of this, of course, is because India is what India is. India, as Mr. Ambani said, is what was originally perceived as a country of 1 billion problems. It's actually a country with 1 billion opportunities. And coupled with all of this, while people realize that in India, if things go to a dispute, things move slowly. The reality is that the world today cannot ignore India because of variety of reasons, which is our demography, which is because of the geopolitical reasons, that India is in a very interesting but a strategically critical spot. So what does that mean for us? What that means for us is that how do we try and ensure that parties stick to the bargain that they had signed up to? So I am trying to see it from a more fundamental question. I think quite obviously, as it happens to a lot of solutions talk about how things should be. But I'm just looking at how things are and trying to see what we have been able to do in last maybe 10 years and then take life from there. So I think today where we stand, in every commercial contract, an arbitration clause is a must. So, have I come across agreements without an arbitration clause? I would say maybe 1 in 1,000. The debate is whether institutional or whether it should be ad hoc. And, it's possibly a discussion for another day that what are the advantages of institution and what are the advantages of ad hoc. But I think the fact that what we call midnight clauses, in terms of our parlance, we say that arbitration clauses are clauses which are never looked at until when the dispute happens. The reality is that if one is looking at an arbitration clause, there is a problem. And if there is a problem in a country which is like India, it's going to cause a disruption. As they say, the path from a dispute to a resolution is a long path, very, very crowded, which is what our court systems are. There are certain bypasses that we come up with, which could be, as Aditya was recommending, tribunalization, where you can have a tribunal, which is what we've tried with a variety of disciplines like SAT, like TD-SAT, like works. We could do arbitrations, but ultimately it will come back to what I call the clogged highway. Because for enforcement, you have no options but to come to court. And today what has happened is a client, when he starts a dispute, and maybe I'm representing that client who the size of the dispute would be large. So who therefore a safe assumption has the resources to deal with it, because I'm going to spend a couple of minutes on how there are occasions where people have an excellent case, but because of want of having resources are not able to pursue it. So therefore a client today looks at life and says, yes, now things have gone wrong, what do I do? And will I be able to recover money? So very often the cart is put before the horse. From a client's perspective who is looking at India again as a country with ongoing opportunities, asks a question saying, do I want to waste my time fighting? Or do I rather just sit across the table, take whatever I get, feel cheated, feel frustrated, but walk away? There are occasions when the client says, no, I want to take the leap. And that's where, we start with issues which start with section 9, section 11, section 16, etc., etc., etc. But the question that I'm going to touch upon today, and which is what we've seen, sorry, that's not me making the noise, right? Yeah, because I've had my breakfast. So, the question really that I'm dealing with is the parallel proceedings which start. And, as Justice Krishna Kumar said, if something goes to court, the court has no options but to look at it. Even if it's an open and shut arbitration clause, if it takes, and 3 months, I'm sure Justice is being very, very kind. Take 3 months, because, if you ask a question, it takes time. That's the way our courts are. So I have seen in my experience, the moment, and I've done a lot of what I call corporate divorces or joint venture disputes. In a standard joint venture dispute, you suddenly have an imaginative story being written about how it was the promoter's idea, which was stolen by the investor, and how the investor led the promoter down the garden path, and it resulted in theft and criminal breach of trust and conspiracy and common intent, and suddenly river discs are pulled out, and you look at who the top people are, and they are named in a criminal complaint. And then starts the stress of, do we do a 482? What happens if somebody travels to India? Is there an expectation that there'll be an arrest? Can there be custodial interrogation, etc., etc., etc.? And I'm again just going to touch upon problems because I am mindful that these are all issues which need a discussion standalone. There are suddenly operation mismanagement petitions filed by somebody who is supposed to be in management and who says that exercise of rights, which I incidentally signed and agreed to, is actually oppressive. And the same problem, the court, the moment there's an allegation, is forced to look at it. But what that means is that that's used as an opportunity to derail the arbitration process. Anti-arbitration injunctions are sought, and in spite of extensive jurisprudence on that very limited scope on which anti-arbitration injunction should even be considered, they are granted. It's all undone. We had an injunction which was passed by a single judge of the Delhi High Court in a joint venture dispute between McDonald's and its franchisor. And it was set aside, but it was set aside after 12 months. And I think the whole strategy really is what I said, that how do you frustrate the other side so that the other side says, Baba, give me 20 cents to $1 and I'll walk away. And which is precisely what the idea is. So that's just one part of the action. And supposing if you're successful in trying to wade through all of this, then you have the second round where, in my experience, and I think the point I was trying to make even earlier is that there are developed jurisdictions where these processes have evolved. So be it the discovery process or be it process of a hearing. I mean, a typical hearing before a tribunal seated in Singapore or UK would be a 5-day hearing, which is where there would be opening submissions, there would be cross-examination, there would be closing submissions, and it all happens in 5 days, done and dusted. Those processes, when they are brought down here, there is resistance in the name of principles of natural justice. There is resistance to technology. I am amazed today when there are occasions when we recommend, and I would recommend it in every arbitration that I do, that we should have transcripts. Because what transcripts do is it forces you to be disciplined. It forces you to be to the point. And in 8 out of 10 of those arbitrations, very often the arbitrator is the one who says, no, let's not have transcripts. What cross-examinations that can take 5 sessions get over in less than 1 hour. When it comes to discovery, and so therefore what we do is, I always cite this, that if I again take back life 30 years, what used to be 5 letters a day, which is what people used to write, today people write hundreds of emails a day. And so therefore when it comes to discovery, when it comes to culling out the relevant emails, there are technology platforms that are available which really make things move very fast. But there is resistance to using them. When it comes to taking procedural directions, when there comes to a requirement to disclose relevant documents, there is resistance. There is resistance to aiding the tribunal in coming to a gut. And so therefore all of this is done with one sole intention, which is how do I get out of this arbitration clause? How do I try and ensure that the adjudication is not fast enough? And so therefore, I think in terms of solutions, what we certainly need is we need standard formats of procedural orders. We need standard formats of how there would be use of technology when it comes to hearings, and we could certainly draw a distinction on, say for example, either the seat, or we could say if it's institutional, or we could say if the stakes are high. There are a variety of things. But with all of this, I think the final question that I'm going to deal with and take a couple of minutes more is when it comes to the courts, and they do face the problem that we identified, that the moment there is a question asked, there has to be an answer. But how do we solve that? And I think what we saw in IBC was an excellent example. The moment there was a crease that came up, the Supreme Court stepped in and ironed it. We had some excellent judgments from Justice Nariman, who was able to interpret those clauses which were ambiguous, those clauses where clarity was needed. And those guidances that were provided were extremely helpful. And so therefore, I think while having specialized tribunals and an appellate tribunal and ultimately an appeal to the Supreme Court is important. What would be very helpful is if Supreme Court has a special bench which would deal with anything which comes out of an arbitration expeditiously. That would provide guidance to the judiciary all the way in the system. So for instance, today what I am dealing with is a situation where there is a view taken that if there is an operation mismanagement, then an arbitration cannot go ahead. And there is a stay given by NCLT in teeth of an NCLAT decision which says NCLT does not have jurisdiction to grant stays. I'm dealing with it, and before the NCLAT, it's been pending for some time and, the matter is being argued. But I think those are issues which one should be able to take directly to the Supreme Court. There could be certain revolutionary things like what we saw when where the judge took a single, the minority award and converted that into an award. Now that, of course, has its own downsides. But I'm saying we'll have to do something which is out of the ordinary, because comparing Singapore and saying things are fast in Singapore is really comparing apples and oranges or grapes and watermelons. Because Singapore really is a dot compared to our country. At the end of the day, what we've seen the Supreme Court do in last 10 years in terms of enforcement when it comes to judgments starting from Vijay Karya, going to Banyan Tree, the Supreme Court has said arbitration is critical, force parties to stick to their bargain, and I think that's what it really should be. Of course, at the end of the day, all of us should remember that the elephant can only walk, it can't dance. So for our country, I think we are doing well, provided we focus on which specific areas need resolution. Thank you.
Thank you, Mr. Barot, for your views. I think you basically flagged three things, if I can briefly sum it up. Number one, changes in the law, the statutory provisions. Then the law has to develop, it's very critical, that judgments, the law has to develop by way of judicial precedents, which would hasten. The third thing which you flagged is the delay on the part of the parties. Now, this, I come back to what I said when after Aditya spoke. Now, this is again left to all of you. Probably now I'm in a position to say that. 5 years back, I would not have been in a position, because I was guilty of the same thing, to be honest. So, this strategic approach of scuttling the process will continue. It was always there, is there today, will continue. So that we really can't change. Each respondent does not want arbitration, come what may, and he is ready to fight it out. Patel Engineering said 226 not maintainable. Writ petitions are still filed. Then Justice Nariman said, if when a question of jurisdiction is there, then it is maintainable under certain circumstances. That is used, writ petitions are filed. Interim orders are challenged. Arbitration proceedings are scuttled. Now, it's left to all the lawyers and the parties to ensure, which I think will never happen. Hopefully it should happen, but right now it doesn't look like it's going to happen. So that we really can't change, and I'm not really expecting any of you to change that also, because end of the day it's the party who is instructing you to take a call. But insofar as the law is concerned, yes, there has to be changes. Insofar as judicial precedents, yes, there has to be development. The right persons being appointed as arbitrators, that can change. The right judges sitting for either a section 34 right now or a section 37 or a specialized bench before the apex court. Yes, all those things are within our hands and we can change. Thank you, Mr. Barot. I think we'll move on to the next speaker. That's Manu, is it? Manu. Mr. Manu Kulkarni.
Good morning, everybody. Honorable judges of our Honorable High Court, Honorable judges of the Commercial Court, members of the bar, senior advocates. I am humbled to be a part of this panel to share my thoughts. The subtopic given to me is, why does India Inc., or if it does, prefer other jurisdictions, if possible, over India as a jurisdiction for arbitration? I have diligently sat through most of the sessions yesterday and today, and unfortunately the overwhelming answer appears to be that yes, India is not preferred. Apart from all the reasons that have been given, two things that I see are, we quite lag behind in terms of the nuance that two developed jurisdictions have, which is again SIAC and the English jurisdiction. Now, I pulled out two examples where there is worldwide a beautiful jugalbandi going on between the English and the Singapore courts, and we unfortunately are not a part of that. So, in an English court while disagreeing with the Singapore judgment, says this: at the risk of failing to do justice to the clear, careful and conscientious consideration of the issue discussed by Justice Vinod Kumaraswamy in so and so. That is one. To further the case, the English court goes on to say that scholars in Singapore have disagreed with the decision and I take support from that fact and therefore I disagree. It is as respectful a disagreement one can imagine, and this is a disagreement in courts where judgments are not binding on one another. A second example, again an English court in praise of a Singapore court saying, I have cited the judgment in BCY versus BCJ at some length because it represents the fullest and, if I may say so, the clearest treatment cited to us. One reason why I believe we are not a part of this nuance is our ecosystem is such that we don't simply spend enough time. And it starts with the bar. Any one of us who has done either international arbitrations or participated in trials overseas knows that it is rarely a one-man or a one-woman show. It is a team of lawyers working through months, if not years, to take a matter to trial. Every finest aspect of law is analyzed, put before the court. I don't think we do that. Because we don't do that, the nuance is lost on us, and therefore, if today a client asks me whether in Singapore law this is the position, it is rather easy to say that this is the position, whereas when it comes to our jurisdiction, it is not so easy because we don't put the kind of effort that it needs. That is the one reason, I think, and where majority of the work is with us at the bar. The second, I believe we have moved on from being disposal oriented to sometimes being disposal obsessed when it comes to arbitration matters. And that simply does not serve the cause at all. Which is why quite often the Supreme Court exercises 142 jurisdiction. The fact that jurisdiction is being exercised so many times by the Supreme Court tells only one tale, that the Supreme Court finds the award unjust. And if that power were available to our High Court, I am fairly certain that power would then be exercised. Therefore, the second point is that we are not developing the jurisprudence in a desire to quickly resolve a dispute. Third, in terms of what can be done, earlier in the day, Justice Krishna Kumar and yesterday, Justice N. Kumar made this point that lawyers have a lot to blame. I agree. But the question is the judicial system, or does the judicial system not have sufficient powers to curtail us? I certainly think there is, but that power is not being exercised. For instance, in a frivolous objection to a Section 11 petition, I don't know if I'm speaking for all members of the bar, but for me I say please impose heavy cost, genuine cost. It will prevent us from taking frivolous objections. In fact, I was reading a judgment of the Supreme Court where enforcement was challenged on, among other reasons, the ground that the cost imposed is a whooping sum of 19 crore. Supreme Court said it is realistic cost, please pay it. Of course, it was an ICC arbitration. So if that is the kind of cost we are expected to pay, I am fairly certain that frivolous arguments will be kept out. I can understand cost not being imposed in non-commercial matters because it could have an impact on the access to justice. But these are commercial matters, these are people who know what they are doing, so they might as well suffer cost. And this imposition of cost should start with the commercial courts. Cost under the regime of the Arbitration Act as it stands can be imposed for a poorly made argument, even in respect of a winning party. To that extent, the cost can be reduced. If this is not done, to use the words of Justice N. Kumar, he said it is wishful thinking to expect that the lawyers will buckle up. Therefore, I say please impose cost in every single case. That would be my third point. The fourth, the travails of a decree holder has been sufficiently covered, but I would like to say that our court has perhaps been one of the first courts in the country to resolve one vexed issue of whether an award requires to be stamped and can a penalty be levied on an award. Unfortunately, in that case, I am for the losing party, the decree holder, because even today, not a penny has been received, proceedings are going on. The matter went from the High Court to the Supreme Court, it came back to the Commercial Court, likely it will go back to the High Court all over again. But step by step, law is getting clarified. Whereas on the international side, Supreme Court has made it abundantly clear that an award cannot be stamped at all, considering the law that is prevailing today, that is the Indian Stamp Act. The fifth point that I make is, I somewhat disagree with both Dr. Sondhi and Mr. Barot. I don't think the Supreme Court should be the court resolving these issues either in appeal or in SLP. It is to me a little strange that two judges of the Supreme Court disagree with each other. It goes to 3, it goes to 5, and then it goes to 7 to resolve one issue of whether an unstamped agreement can be looked into. I believe that this is what should be done at the level of the high courts. I don't think there should be a direct appeal to the Supreme Court even if the law were to be amended. I think a division bench of the High Court should be where all of this law is settled. If only there is an irreconcilable conflict between various high courts, should there be interference by the Supreme Court, and only under 136. Otherwise, it becomes strange that Supreme Court is the first court which is laying down the law and not the last court, as even in the case of group of companies doctrine. Supreme Court disagreed with itself over time, and then finally 5 judges of the Supreme Court had to resolve. I think that is a somewhat lopsided development of the law. That law must develop here. The last point I wish to make is that when it comes to international arbitration, the law that prevails is largely in favor of quickly and meaningfully enforcing an award. There are procedural hassles in terms of the law requiring production of a certified copy of an agreement, original copy of an award, but the law is meaningfully settled. It is the application of the law and imposition of serious and meaningful cost which will ensure that that law is enforced. Thank you.
Thank you, Manu, for your frank and open thoughts. In his over-enthusiasm, he seems to have forgotten that tomorrow he has a CMP in which he's been dragging before me for the last 1 year. You'll be the first victim. Send his junior tomorrow. By the way, thank you for representing the Advocates Welfare Fund. If we implement this, we can make crores, rather the lawyers can make crores. No, but on a more serious note, it's definitely a good thought. Personally, and I think even Justice Anand Reddy is here, I think we have never imposed cost even in a single matter. And we draw a lot of inspiration from his lordship, and I don't think I have so far imposed cost in any matter. So the tendency is not to impose, the tendency is to assume and presume that lawyers will cooperate, and they have been cooperating. Therefore, in an extreme case, to impose cost theoretically is definitely very good. But I would personally feel that if the lawyers cooperate and ensure that the matter gets concluded, then even this imposition of cost will not happen. More so, the other aspect is, assuming that we impose cost, only the portion of the order which imposes cost would be challenged. And then there's a possibility that the proceedings may get stayed. So from that angle also, there's something that needs to be looked at. Probably Section 11 itself can be amended. And then, yes, our hands will be strengthened in imposing cost. Otherwise, even our tendency to impose cost will be based on many factors which are beyond the law. Insofar as procedural delays are concerned, I think I missed out when Mr. Barot said, yes, even the process, the procedure of the trial, the inquiry before the tribunal, there are various provisions of the CPC and the Arbitration Conciliation Act which can be used by both parties and the tribunal for minimizing the timelines. And as Aditya said, Section 29A, finally the law is well settled, but then again, if the High Court cannot extend the time, it's only District Court, that again contributes to the delay. Now all these are, the reason we are discussing all this is the central theme is to minimize the delay in and to ensure that the foreign investors are in a good space when it comes to looking at India as an arbitration hub. Thank you, Manu. I think we move on to the next speaker. Mr. Karan, please.
Justice Mudgal, Justice Nawaz, Justice Krishna Kumar, Justice Uma, Justice Poonacha, Justice Anand Bhaira Reddy, my esteemed co-panelists, learned judicial officers, my friends and colleagues from the bar, ladies and gentlemen. I've been to a number of these panel discussions, and today is special for two reasons. One, of course, the fact that the bench is so intrinsically involved with the ADR week. This is something that I haven't seen before, so my compliments to the organizers. The second reason this is special is because after many, many panels, I'm finally on the same panel as my senior my senior and mentor, Mr. Sondhi. So, Justice Krishna Kumar just spoke about how we need to perhaps give a degree of comfort to foreign investors who want to invest in India. Now, once in a while, I don't do any corporate work, but once in a while I get some contracts to oversee. And when it's between Indian parties, I've been able to convince them to either put, make it institutional and say it should go to our center here or to some of the other institutions that are in our country. But the minute there is a foreign party involved, the number of times I've tried to get an institution in India appointed, I have failed miserably. There's not one party that has agreed. So if I were to deconstruct why, it would be because the minute you look at foreign direct investment, one needs to look at what drives FDI in India. There are three things: political stability, regulatory environment, and infrastructure. I'll focus on the last two, which is regulatory environment and better infrastructure. Now, when it comes to the regulatory environment, we can't look at commercial arbitration in isolation. We'll have to look at it from the lens of investor-state dispute settlements. If you were to take the White Industries case, right, where there was White Industries had an arbitration with Coal India, an award came in, I think in about 2002, and then enforcement was sought, and nothing happened till 2009. An award was passed against India because under the treaty, we did not provide effective means of asserting claims and enforcing rights. Interestingly, this clause of enforcing rights was not there in the India-Australia BIT, but what was there was a most favored nation clause in that BIT. So this effective means of asserting rights was pulled in from the India-Kuwait BIT. Right? The next was the Vodafone case, where tax was applied retrospectively. Incidentally, the Supreme Court said tax could not be applied,
And then to overcome that decision, an amendment was brought in and tax was made to apply retrospectively. What did Vodafone do then? Vodafone then went and invoked the India-Netherlands BIT, right? Where the award came in 2020 and the tribunal felt that there was a violation of the fair and equitable treatment clause. So what was our reaction from a regulatory point of view when this happened? Of course, in Vodafone, India raised a jurisdictional challenge and said, look, you don't have the jurisdiction. Now, the minute that was rejected, perhaps because of the rejection and what happened in White India said, look, we've got about 70 BITs, let's terminate or withdraw from all 70. So what sort of message does this send to an investor where we withdraw from BITs? Of course, we've now got a model BIT. I think about 3 countries have signed it, and no one else has. India is not a signatory to the ICSID Convention. And of course, I'm not saying that we should be a signatory to the ICSID Convention. But all of these things matter to a foreign investor who seeks enforcement, because that's essentially what an investor is concerned about. They're concerned about how, if we were to get an award, how are we going to enforce it in India? And that's essentially all they care about. So from a regulatory standpoint, perhaps that is the wrong message that we have sent. Now, if we were to look at the 2019 amendment to the Arbitration Act, the amendment essentially makes sweeping changes to Section 11, where the appointment by the High Court or the Supreme Court is to be done away with. And the appointment is to vest entirely with arbitral institutions that are designated under the Act. Now, great move, but it's been 5 years now and those amendments have not yet been notified. Ideally, if they are, the Section 11 jurisdiction that comes before the High Court and the Supreme Court just goes entirely. Now, there is so much uncertainty. Of course, the 1940 Act never contemplated investment into India, nothing of the sort. I think it was more focused, of course, apart from dispute resolution, just ensuring that we were compliant with the New York Convention when it comes to enforcement. But the 1996 Act, of course, the 2015, the 2019 amendments make phenomenal changes. So in that sense, I'd say that our arbitration jurisprudence is quite nascent, and we have made compelling steps in the aid of arbitration. Strides really, but then the minute that happens, you have a Delhi Metro judgment. Now, Mr. Sondhi spoke about how after 5 rounds, eventually the award was set aside. This is something absolutely unheard of. So how am I to tell a client that, look, there is judicial certainty or there is some certainty to awards that are being passed? It becomes very difficult. I've had to send out 3 updates to clients saying this is what has happened, right? So, and of course, being a curative petition, this is unheard of for a foreign client. So while jurisdictions like the United States are looking at class action arbitrations, we are still grappling with issues such as this. We're figuring out whether awards should be set aside in full, whether they can be modified. So I think there's a lot of room for us to grow there, but I think we are making some strides. So to my mind, I'd say investment is coming into India not because we're a good place or a safe place, but it's coming into India despite it not being perhaps the most conducive environment for enforcement. And that's something that we need to change. Now, the reason people look at arbitration is because they don't want to go through the court process for whatever reason. So we're going to have to turn to institutional arbitration. Now, what is institutional arbitration? Where you appoint an institute and you say, look, the arbitration, everything happens under the aegis of this institution. Now, much has been said about SIAC, LCIA, ICC. All of these institutions are, I think, at least 50, 60 years old, and all of them keep going on revising their rules. Now, if we were to take our own arbitration center, that hasn't happened for a while. Now, and I'll point out how perhaps there could be some improvements. Everyone keeps talking about how there should be a specialized arbitration bar, right? Everyone talks about how Section 34s perhaps should go to the High Court. Maybe it should go before a specialized tribunal. But no one talks about an arbitration bench. No one talks about how important it is to have qualified arbitrators who are not too perhaps bogged down by the entire court process. The idea of arbitration is that you're not in court. So no one, I think people should focus more on that. Now, when it comes to our arbitration center or other institutions in India, everyone talks about how we don't have space, the infrastructure is crumbling. To my mind, that's not important. I don't think we should play at making 20 rooms, 30 rooms, none of that. If you look at all the world-class institutions abroad, their focus is on a robust set of rules and not infrastructure at all. SIAC, for instance, perhaps has 3 rooms. All arbitrations are conducted outside. All they have is a great set of rules. They act as a registry. They don't have stenographers. They have live transcripts, all of which I believe there are institutions in India, for instance, who offer live transcripts at about 3,000 rupees, right? Which is definitely cheaper than expending a human resource to do that. So I don't think we should be focusing on the space. I think we should be focusing on the quality of the infrastructure that we can provide. And this is not something, I had a chance to discuss this with my panelists earlier, and this is not something that only rich people can afford. There is no reason why you cannot have an arbitration from your office. If at all you need the physical space, perhaps it's only for cross-examination and nothing else. So honestly, I think our approach to making sure that we have a world-class arbitration institution in Bangalore should focus more, or should focus less on the physical space and more on a robust set of rules. The other thing that perhaps we can improve on is emergency arbitration. I know Mr. Sondhi has been appointed as an emergency arbitrator in an arbitration, but our rules do not provide for an emergency arbitration. If we are able to provide for an emergency arbitration, perhaps we don't have to go to the district court for a Section 9. Right? The idea is that you go to the arbitral tribunal for everything and Section 9 is an exception. But the minute we're able to provide for emergency arbitrations, I think that will only perhaps aid the idea of arbitration. Our rules have a consolidation of proceedings, which is where if parties are the same, all of these proceedings can be consolidated. Now, unfortunately, our rules make consent one of the requirements for consolidation. SIAC, for instance, does not take consent. All it looks at is if the parties are the same and if the subject matter is somewhat the same. Even the arbitrators don't have to be the same, not necessarily. And there the registrar of the SIAC will decide whether it should be consolidated or not, consent notwithstanding. And why do they do this? Because it's a waste of resources to have multiple arbitrations. We need to bring in expert evidence. We have Section 27 under the Arbitration Act, but it's barely used. We need to bring in valuation experts. I know Justice Ravindran often speaks about how we just, for the sake of it, someone puts in a 100 crore claim, we will put in a 300 crore claim. Because of course, perhaps the fee is not payable ad valorem in that sense, unlike how it would be in court. But realistically, if we were able to appoint valuators, and there are valuators even in Bangalore, to say, look, this is my case, please assess my claim, and let me know what damages I can claim. Right? I think that will cut down the work of not just the lawyers, but also the tribunal. Now, I will admit, of course, this takes a lot of maturity on our part to actually do that. I do not think that we can play at being a global power at arbitration at the outset. I think we need to focus more on being a regional power. Like I said earlier, everyone is only concerned about enforcement. So what does the European Union do? The EU says that if there is an award passed in any EU country, there are special sets of rules for enforcement. We need to be able to provide that comfort to growing economies, South Asia, Southeast Asia, Africa, for instance, where we say, look, if there is an award from any of these jurisdictions and there are certain assets in India, we will give you preferential treatment. There will be a separate set of rules to ensure that enforcement takes place. So I think all of this will help us be a regional hub beyond which we can go on to the truly international stage. I'd like to end finally with saying that another thing that we should do is start looking at sector-specific arbitrations, which is either IP arbitrations. Now, I understand you may not be able to arbitrate a pure infringement dispute, but there's no reason why you cannot arbitrate an assignment or a license dispute under IP. Similarly, tax disputes. I think that is something that can be arbitrated as well. So if we're able to bring about these changes, I think they're going to be great steps in making sure that we grow as an institutional arbitration hub. Thank you.
Thank you, Mr. Karan. You covered a wide range of, there were many suggestions, very relevant. In fact, as you were talking, I was thinking, and I was thinking as to whether you should have been the first speaker even before the inaugural speech, because you're talking about a dedicated arbitration bench. We had the Honorable Chief Justice here. You're talking about the change of law. We had the Additional Solicitor General. You're talking about infrastructure. We had the Advocate General. Then you're talking about the arbitration bar. Then we had Mr. Vivek Subbareddy. Then we had the Honorable Judges of the Supreme Court. So I think the takeaway from your speech is what all of us witnessed on the inaugural, on the date of the inaugural function, where all these suggestions, there was a banter, if you remember. Aditya wasn't here, but Karan was here. And all of you were present on that day. There was a little bit of banter between Vivek Reddy and Shashikaran Shetty. But all these suggestions, I'm sure, will go a long way in ensuring that FDI will really happen and grow in India. Thank you, Mr. Karan.
Thank you, Justice Krishna Kumar and members of the panel. That was indeed a very insightful discussion, and thank you for sharing your valuable experience. We would now like to call upon Justice Punacha and Mr. Prashant to offer a token of our gratitude to Justice Krishna Kumar. Prashant, if you would also. If I could request Prashant also to offer a token of our gratitude to Dr. Sondhi, who has made time from his busy schedule and is here from Delhi. Prashant, if you could also do the honors and offer a token of our gratitude to Mr. Rajendra Barot. And to Mr. Manu Kulkarni as well. Thank you, Karan, also for joining us today. Thank you everyone. Thank you to all the panelists. To our audience, we are taking a 15-minute tea and coffee break. After that, we reconvene here for the final session of the arbitration week. That will be a parliamentary debate where we need your active participation. So please do be here before time. 11:45 is when that debate begins. Thank you so much.